Well, good evening, everyone. For everyone here in my time zone, it's happy Tuesday evening. For everyone else, everywhere else, whatever day it is, Wednesday or time, I hope it's a good one for you. Thanks for joining me. We've got two to bring you up to date. Not too much has happened with either case, Bryan Kohberger or Sarah Boone. But what did happen was very, very interesting. In something I thought you'd like to get your teeth into. And one of them, especially the Kohberger, has to do with questions we had the last time we talked about him in regards to DNA. So I'm wondering, who do you guys want to start with? Kohberger or Boone? Hello, Mrs. Cassandra and Liam. Thank you for being here, and Maudie and Juju B. Oh, and Mousie's. Oh, and look at the trees and Anna. It's nice to see you guys. And I'm looking forward to a good conversation tonight, hopefully. Um, Kohberger, please. I am still over. Okay. All right. We'll go with Kohberger. Okay. And no problem, Juju. I know. Yeah. I do hope he understands why I had to bounce. It was very interesting stream. Very, very interesting stream. Okay, let's start with Kohberger. And this is just gonna be me giving you the facts. No presentation today, no bullets, no fancy pen in the air to distract you, because I just want to do this quick and dirty. But give you enough time to ask questions and get it off of. The last time that we talked about Bryan Kohberger, the DNA evidence came up. And I said the word blood. And that was a mistake because the DNA evidence that they have on Bryan Kohberger is touch DNA. Okay, which means like other types of cases, when the suspect gets near the victim, touches anything around them, their skin, um the victim fights back and gets some kind of tissue, whatever. Touch DNA can be in many, many different forms, but it's usually sloughed off cells from the suspect, leaving touch DNA. The touch DNA was found on near the clasp or the sheath that held a knife, and that sheath was found near one of the victim's body, almost a little under it, under the cover, in pretty good contact in that area. So I wanted to clarify that, what evidence we're talking about. But the controversy about the DNA evidence comes in the way they identified Bryan Kohberger in what they had to go through. Okay, there is two initials for two terms that let me just get my facts up here really quick for you, because one of them is investigative genetic genealogy. One of the terms that's going to come up a lot is that the defense is actually, well, this is the one piece of evidence that they have, okay, that puts Bryan Kohberger at the scene of the crime at some time. Maybe not that moment, but he was there. But based on where they found the touch DNA, it's pretty damning evidence, okay? But now we have to talk about why the defense is trying to discredit that evidence. And they're trying to discredit it by how it was collected and then the testing in itself. They are trying to go against the testing because DNA evidence to a jury is pretty convincing in almost in a majority of cases. Would you not agree? I mean, I think when it comes to proving if someone was there or not, it can be, or has anything to do with it, it can be pretty damaging. Okay. Now, having touched DNA, it does not tell you how long, when that DNA got on there. Okay. Well, let's just start with the definition of touch DNA. Okay, that's DNA transferred from a person to an object via contact with that object itself, whether that be the knife sheath or the skin of someone, or anything, or the knife itself or the pillow, something. Okay, in the literature, this form of evidence, and this is the scientific literature and also evidential investigative literature that they use. This form of evidence has also been called contact DNA, trace DNA, or transfer DNA. It has been referred to in multiple documents that I saw as touch DNA or transfer DNA in this case. Okay, but it's not referred to as blood, as I misspoke last time, and I want to make that clear. Whoop, just wipe that out. Nothing that I found says blood anywhere. Okay, and that's one of the defenses. Jay Langston made a big point in his brief about the DNA evidence, is that there is no blood DNA evidence anywhere in relationship to Bryan Kohberger. Not his home, not his office, not his car, not any of his at the site. Period. They made a big point of that. They're trying to discredit this small amount of DNA evidence that they have, and they're trying to discredit the means in which they got him as the suspect. Okay, how long does touch DNA actually survive? Up to 2 weeks, or up to 6 weeks longer if inside. If it's outside, 2 weeks. If it's inside, up to 6 weeks. So that touch DNA, when they finally got it to the lab, they took it to the lab, and through their specific testing, they found DNA on it. It was not visible by the eye, of course, so it wasn't a spot of blood or anything like that. It wasn't visible until they took it to the lab and did their testing on it. That's when they found the touch DNA of one male. They did not find any of the victim's DNA. They didn't find anybody else's DNA on the sheath, the knife sheath. Okay. That touch DNA can be made up of shed skin cells. It's transferred from the donor to the object, and it has to have physical contact rather. They actually use this to gather profiles and trace biological evidence to use in other places. Okay. Yeah. Hey, Tony, how are you? Yeah, inside, meaning inside, like covered, like inside a building or covered in some way. They don't mean inside the body, but I mean, it could mean inside the body too, Mrs. Cassandra. But I do believe that they mean not exposed to the elements. Okay, as Liam had said. Okay, so that's the type of evidence. And now let's talk about the technology that they used. Okay, in the beginning, they used the investigative genetic genealogy. Okay, when they came through and they tested it that way, they found that there were some relatives that could be related, that they were not a strong match. Okay, but enough to lead them in that way. Okay, there is other evidence that they're saying that led them to actually say it is Bryan's DNA. And that is because once he was arrested, after DNA in his parents' garbage linked to the first DNA touch analysis, that the DNA that they got from the garbage matched that it was probably a high probability of being a father of the suspect, of the owner of the DNA, so to speak, from the touch DNA. Now, they got that sample at the parents' home in Pennsylvania prior to Bryan's arrest, and they narrowed it down to try to get to Bryan. Okay. Once they found that it was a match familial through IgG, investigative genetic genealogy, Bryan was then arrested. And when Bryan was arrested, he gave a cheek swab. And that particular cheek swab did come back as being an astronomically positive match. Okay. That match was done by STR, which is a technique that is used. That is the standard. Now, no one really argues with the STR. Everybody says that STR being the standard. And let me find you the full definition of that one. Um, in the Justice Department lists that STR is short tandem repeat analysis, which means that when you use that DNA to distinguish like two individual ones together as being a 90, it's like a 99% match. They match multiple codes of proteins that they do not vary much without rendering those proteins ineffective. So it's very easy to match up these profiles. Well, not easy, I should say. It's very sophisticated. I would say it's a pretty solid test. Okay, they use all kinds of amino acids in specific coding to create that those DNA based sequences are not altered or mutated. Okay, and then they do this short tandem repeat analysis, and it's done through the swabs, and it's what's done every day in the justice system. Hey, Kelly, nice to see you. Happy Tuesday. We're talking about Kohberger. Hey, Recker, I see you. I see you slid in there too. Nice to see you too. But about the DNA testing, it's a little iffy using the IgG because a lot of people don't understand it. And there is a great case in to say that, the swab testing that they do, that they send to your home to do that is, could it be like not the best? Probably, um, well, that's why I'm going to give you this from a scientist who did an affidavit for the defense in regards to the way the IgG testing was done, just so you understand their argument, because it's very important for the defense to make sure that they have the information and how the DNA was lifted from the sheep to make sure it qualified. It could not be tampered with. Because here's the other thing I learned in my research today that I don't know if any of you were aware, but there were two other male DNA samples that they found within the home, but I can't find out where they were. I don't believe they were in the bedroom scene of the crimes. What were they in the home? And then a week after the crime, they found a glove in the front part of the yard with DNA on it. And that also was a male. Now, those names are not released, and those people may have been eliminated. Now, don't go running willy-nilly, and I know none of you in the chat or listening to me will. At least I don't believe so. You've all been quite reasonable, and not like mainstream media, who really kind of pisses me off when they go on a tear with this kind of stuff. Well, that doesn't mean that they're suspects. If they only found two other males or DNAs, it could have been boyfriends or acquaintances, brothers, family members, delivery people, anyone that could have been excluded. Okay, we don't know who else they tested, but I'm sure they have the names of other gentlemen that were in the house at any time from everybody else who lived there, so that they could cross-check this. And there could be a reason that that's not allowed here, because those samples have been eliminated. But the defense wants to know for sure. And they have a right to. And so the defense and the prosecution have been going back and forth about this. It's not that the prosecution doesn't want them to have the information. Here's the problem. It's a twofold problem. One, they used an outside lab to do the analysis, okay, on the specimen, and they can get the reports for them. But the FBI did a lot of testing for them on their own. And it seems like the reports are being held up on the FBI side, mostly because they have to go through a lot of red tape through the DOJ and the DOJ rather, in the Department of Justice, to get these released over to the court. Now, to help expedite that and to help the prosecutors and the defense in, not to have it take too long, Judge John Judge has taken it upon himself to issue an order saying that this DNA evidence needs to be presented in all formats into how they collected it in the reports by December 1st to him directly. And he wants to do an open camera investigation of the evidence to decide what will be released to the defense. He wants to see it first because it's investigative genetic geology. There are people's names, birth dates, addresses who do not have anything to do with this case listed, and that all needs to be redacted. Okay, because it's not part of the case, and it's not something that the defense is entitled to. You know what I mean? And I give him credit for that. He also clearly admitted that he is not an expert in DNA and he doesn't know that much about IgG. There have been only several cases in Idaho that have used IgG in the beginning, and that is investigative genetic geology testing to narrow down the suspect pool. Now, did they pick the suspect based on IgG? No, they narrowed down the suspect pool. We have to keep in mind that Bryan Kohberger was not arrested for this crime. With when they pulled him in, they got that cheek swab and they confirmed that it was a total match to him, not just suspected to be him because of the father connection, but it was him. He does match, in a very, very high percentage to the touch DNA. No doubt about. The father, not so much. But it was what they said, a 5 to 27 octazillion percent that there would be anybody else that it could be. Now you say, what is an octazillion? Well, that's the number 1 in the 27 zeros. So they did narrow that pool down to that Kohberger family specifically quite easily. But here's the problem. The testing to submit your DNA into the databases that are used for IgG is not exactly notoriously perfect. They'll say that. Okay. There's a lot of ifs about it. Also, you do not have someone with a lot of knowledge doing the test. You do it at home yourself. I mean, granted, it's a swab in most cases. Sometimes it's blood. But it's not like going in and giving a blood sample for DNA or anything like that. Okay. So there are a lot of variables. And whenever there are variables added to a situation, if there are variables in there, you got a hook for the defense. The defense should, and rightly should, look at this and say, hey, this is an angle we should go at. And this is why they're attacking it twofold. Not only because IgG was used and it went to the father first, and then they did the indictment based on that, but also because IgG itself is not that well known or that well produced throughout the court system right now legally and has a good following and standing and outcome. Okay. And because the test is done at home that submits the database DNA that is used to do the cross checks. And yes, that's what's used. You do a cheek swab for, 23andMe, and it goes into the database, and that is the database they used to narrow down the subject pool in the Moscow murders. That is what they were comparing it to. Now, it doesn't mean that they didn't first do all the normal stuff. They did run it through Codex. So they ran it through everything that they have. But that's all convicted people or suspects that have been entered into Codex. And he was what you'd say off the radar. Not in the system. He hadn't done anything wrong. His DNA was not in there. In that means. So then as commonly is done in investigations these days, but it's not actually entered the court system as strong yet. But as far as private investigations and stuff, IgG is used a lot. We've been hearing about it for years, have we not? In many cases, Anna, are you getting the O.J. Simpson vibe with this? So I could see your comment, but I wasn't quick enough to get it up there because I have the picture up. But anyway, I found it fascinating, the argument that they have, which is why I'm giving you the affidavit for the claim there. I've got a couple of other articles I want to link for you on it. If you're interested in this kind of stuff, I found some, forensic reporting on it that you might find interesting. And I'll be linking all of this in the description later too. But for now, there's a couple of articles, that definitely, well, it did open my eyes a little bit. Okay. And I'm thinking it might yours too. Just a bit. But here is the article indicating the other DNA if you want some more information on that. Now, there are no charges and the investigation on the other DNA has been dropped, but the defense, of course, is going to bring it up. So they're going to have to show like they excluded someone based on it. That's going to be very important in the trial. And I think that is why the defense is being so adamant about getting their hands on all of this DNA, how all the detail of the DNA evidence, Now, the meeting was on Thursday, okay? That was November 2nd. And it was a Zoom meeting right under the court. Kohberger was with his attorney, Ann Taylor. Jay Longstein was not there for this one, but Ann Taylor was. And she was in the basement below the courthouse with Bryan Kohberger, okay? And they went by Zoom. I'm being told through different sources that I've researched that's not unusual because this was just a status hearing. This was a status hearing on this DNA motion, in order to, present DNA. The defense was saying that every time, with discovery that they approach it, there's a delay on the prosecutor side. Prosecution, which was it was attended in the Zoom by Bill Thompson, prosecutor in this case, that the delays are basically on the reporting, and that there is a lot of information, and that's when judge decided, well, you give it to me, and I'll be able to redact all that is necessary. He did say that they, the labs that the private lab that they used, the Idaho State private, and the private lab, and the FBI, where all the sources of information will be coming from, what kind of information they have to release, which all seem to satisfy the defense as long as it comes forward. The defense then clarified, and Taylor clarified, she was not looking for names and addresses and people's ancestry or anything like that. Well, she had a right, and rightly so, in presenting Bryan Kohberger's case to understand how they collected that DNA and what they did with it and how they got to the conclusion they did. And more importantly, when they did. Because, she's trying to infer that there's even been some rumor that they're trying to infer that the DNA was planted because they just needed something to connect Bryan because they had spun their wheels another way with all of the cell data and the phone tracings and then the vehicle sightings and all of the CC cammering. Because remember, Bryan Kohberger was not arrested until a month after the crimes. The crimes occurred going to be a year next week on the November 13th. And he was arrested in December and indicted. And they had time to build a case. So the defense wants to clearly see where and when they made certain decisions in regards to the DNA. And I actually am quite impressed with the defense on this one. Because when I'm looking at it, and here's where I would like some feedback from you guys, is I'm looking at it like this DNA is so important. This is a make or break in the case. If you can't prove he was there, they have a eyewitness that cannot identify him as him, but that she saw someone, and they've got touch DNA. If the touch DNA gets thrown out, we have Bryan Kohberger supposedly in the area, but that's a different scenario than Bryan Kohberger in the room. You see, that knife sheath being on the bed with the body kind of indicates he was there. It doesn't say when the touch DNA got on it. Okay. And then, on one side, I saw arguments on Reddit where people were saying, well, that means that anybody who handles a knife in a store before they buy it, like, could get arrested for touch DNA. And I'm like, no, they can't, because it's what they call the process of elimination and alibi. And without anything else added to it, you're not going to get arrested on that. There would be video cameras in the store of you touching it, which would be a valid explanation on how your DNA got there, and no charges would probably be pressed if that was all they had. Also, you could have an alibi. You know where you were. Just prove it. In no charges. Okay. Touch DNA isn't that dangerous. It's a valuable resource for investigation. But when you look at it, it's the match of Bryan Kohberger to the touch DNA that secured the indictment. The cheek swab. The charges. They're going forth for arraignment. There's enough evidence there to go to trial. The grand jury, once they had that cheek swab, said there was enough to go to trial. Okay. It could be that they went, when things are this public, the 4 weeks before Bryan Kohberger was arrested, the media was in a frenzy. The town, everybody was so upset. They didn't have a suspect. They weren't looking at anybody. Everybody's talking. Everybody's doing all of this stuff. Okay. And the town is scared. The people in the area are rocking from the trauma of the events. Not just the families, but everybody. It's a university town. Okay. Lots of young people. People were leaving, everything. Mass media was swooping like crazy. Okay. Things were pretty heated. So it really, I can understand why the prosecution went with a grand jury closed behind doors to keep it out of the media light, rather than having a evidential hearing before trial as they do. There's two ways to do it, and they chose the other. And I think it was it was the stress of it being such a huge case in such overwhelming media spotlight. I do. I think that's the reason it went that way. But let me just check for questions, because then I think I'm going to move on to Boone. And I'm also going to put my banner on. A little late, but it's there. I know it's hard to imagine, like, I hear you, Liam, in regards to the number of an auxilian, which is like, 1 in 27 zeros, is like a number beyond what I can normally think to calculate in anything in my life. I know, Juju, I doubt we know any, it's been, the fact that they did the closed grand jury, a private grand jury like that, like, they saw the evidence. Like, they may have seen more than us in the, absolutely, because they were positive it was an okay. It does look like it could be a battle of experts, though I am not sure how I feel about that. It's always a battle of experts, but when it comes to something this scientific, what will happen is it's just going to confuse the jury. They're going to dismiss it, and that could be detrimental to the prosecution's case and a huge win for the defense. And that is why they're going this angle. Just think about being on that jury and having all this thrown at you and trying to figure out what testing's the best and what should or should not, and the ramifications of it. It's going to get very, very technical, and there will be, one person who says it's like great and somebody else who says not so much. Oh, I'm sorry, Sheila. I do hope you feel better. Don't worry, we got it. You take care of you. You know how I feel about that stuff. You take care of you first. Okay. I'm just looking for other questions that I may have missed. I got to go back. I find difficult to believe that the party girls didn't have other males in the house or even their rooms, and the police couldn't find out from pictures and etc. I'm sure there was, but they're particularly honing in. They mentioned too, This was a news article. I'm not getting this from a legal document. This was a news article that I shared with you guys. And defense had made statements in public about the other DNA. And this was before the gag order. And then after the gag order, nothing, of course. Okay. It does not, yeah. Could have been prior property renters. It could have been, except for the fact that touch DNA, as we said, even inside in the house would only last 6 weeks. Okay, outside in the elements, up to 2 weeks. We looked all that up on research and on forensic evidence profile pages, and that's what they were telling me. 2 weeks, exposed to the elements in 6 weeks if it was inside. Thank you, Mark. I'm glad I got my ears sorted out. Yeah, I do look much happier, don't I? Like, I feel much I hope I sound much happier. I mean, my avatar looks the same no matter what, but I know you can tell by my voice. I am much happier. Much happier. Okay. All right. So, anyway, I wanted to clear that up about the DNA and why they had a separate hearing on it and where we are with it. So, December 1st, judge or prior, if they get it, judge is going to be reviewing all of that, and he'll give it to the defense, and then I'm sure we'll have other motions afterwards on exclusion based on anything they see in there they don't like. They're trying to get this evidence to us, and I think that they're trying any angle they can. I have to say, as far as the defense team, Bryan Kohberger, he's got a good for defense. For public defenders, he's got some damn good attorneys. Okay, Ann Taylor and Jay Longston are going to battle for him. They have not only gone against how the grand jury was given instructions, and now they're talking about, well, like, you better give us step by step exactly how you got that evidence and when you linked it. When did you link it to Bryan Kohberger? Because that's going to be the key on whether it gets tossed or not. Any impropriety. And it's not unusual for the defense to go after the investigation. After all, the investigation is what leads to the evidence against your client. So, no investigation is perfect. So their job's to find the cracks and stick something in it and spread it wide and make it more confusing for the jury, or have the jury dismiss it, if it even gets entered into evidence based on what happens. Yeah. Well, all right. So, next on the agenda, Sarah Boone. We thought Sarah Boone was keeping herself quite busy writing letters to Judge Wooten. And I've read to you quite a few of them, and we've scoffed, and, and at the same time, we really feel for her being in jail this long, since 2020, with no trial, going through all these attorneys, some through her own fault, but other through theirs. Okay. We have to admit she has not had a good run. She is annoying, but she still deserves a fair trial. And it's getting really, really dicey for Sarah Boone. And I'm here to tell you, Juju, don't get too excited, because this doesn't have much to do with the murder case. Okay. Her second-degree murder case, okay, through indifference and all of that. We're not going to talk about those letters. Because apparently, it does kind of is related to it, but it's not. We have the same defendant, Sarah Boone. And we're going to be talking about her divorce agreement with one Bryan C. Boone, her ex-husband, who, since the day of her arrest, has not paid any alimony. Now, that's a problem for Sarah Boone, because she wants experts and she needs to pay. She would like to pay for an investigation. She would like to pay for an expert witness, because if you remember, in some of the other reporting and discussions that we've had, Sarah Boone's attorneys were having difficulty getting their expert witness paid for what Sarah wants to put forth as a battered woman's defense. She wants a battered woman's defense, and she has an expert who will provide that for her. But unfortunately, since Sarah Boone does not have any resources of her own, They have to go through the trial court. There's a limited amount that you can pay these people, and her expert witness is unwilling to accept it. And her prior attorney, Frank Bankowitz, was going through the process of getting the judge or getting the actual judicial trial court system that pays for these things, the TCO or whatever they call it in Idaho, to actually up the fee because there was such a limited availability of people. And that never happened because Frank Bankowitz walked away. Okay. And we actually heard that, right? So there's that. She needs the money, even though she's got a roof over her head and she's all fine. But there's some legal things in regards to this. Juju, here's why he doesn't have to continue to pay right now. He filed a motion to reduce the alimony payments to reduce or negate alimony to Sarah based on her current as soon as she got in there, based on her current situation. She no longer needed the money to support herself. She's in jail with room and board. The alimony was because she could not take care of herself without him, but they were divorcing. They have a shared custody agreement. He now has all the custody. He legally has the right to petition the court to stop those payments or reduce them based on the new situation. Well, over the last 4 years, Sarah has had a fit about that, and she has been writing to Judge Michael Dean at least 16 other times. But most recently, this September 5th, she wrote a 7-page letter to him, imploring him to do something about this because in her complaint, not only is it along the same lines of the other letters to Judge Wooten, nobody's listening to me, nobody cares what happens to me, I have to take care of everything myself. Why don't you take care of this? She says he's turning my son against me. He's punishing me for something that's out of my control. He's, his beliefs are not the end result. Like, I haven't had my trial yet. There's nothing that I can do. I now don't have a bank account because he's not sending my alimony, so they closed my account. And another thing, she's like really pissed off that she can't get a copy of the dissolution of marriage because she can't pay the fee to get it. And this all happened prior to the murder. So like she could have made those arrangements prior, but now she wants it and she can't, And so she's really got to be in her bonnet about it. And the letters are pretty much the same. But in this case, something different happened. Okay. There were some things, and I'm going to link you a video on Sarah Boone that the lawyer did. Okay. That sometimes I watch his stuff, but he read the letter and he brought up some very good points. He goes into a little more detail, but you could see the letter there and all of that. But he did a little bit of research on what was allowed, and it was talking about. You have to remember, this is family court, not regular court. Okay, so everything is a little bit different. Okay, when he petitioned for it to be stayed, they could either put it all into an account or just stay it until it gets heard. Well, here's the thing that happened. She was trying to get a lawyer to fight for her. She actually contacted, the Justice Department in that area for them to be able to come up and give her free counsel. And they said because she's like in a safe place, they said they just can't handle every case and they have to weigh it out on emergency. And they did not feel that Sarah's case in regards to the alimony, because it didn't really right now. I mean, even though she's in jail, she is being taken care of. She got room and board. She's at no risk of being homeless or unfit. And so like she went to the bottom of the list and they just referred her to the regular legal counsel in the area. You can get a free referral, but you're going to have to pay for them. We can't take your case pro bono. Okay. So she attached that letter to Judge Michael Dean that she sent in September and just pleading with him to do something about this because she can't even get counsel. She can't afford to anything and she needs to be done. That's just not right because she repeated some statements that her child made. Like, you could say whatever you want to the judge. They're not going to believe you. Dad said so. I lie to you because I can. Dad does it all the time. This is her child talking to her, and she says this is what her husband is feeding to him. That her husband has actually said, I'm not going to pay you. I don't have to pay you. You've done this thing, and we'll leave it to the courts. Like, stop harassing me. Things like, you don't matter to our lives anymore. Well, that kind of bothered me that he said that to her, including the child. Regardless, she hasn't been committed. He can feel the way he wants, but she's not guilty yet. She's in jail. Well, come on. Like, that's the child's mom, and she was in his life prior. Yeah, her ex, well, let's just say she is quoting that in the letter, handwritten, okay, to the judge that he said that. There's no corroborating evidence, of course. It's kind of a he said, she said, but she said that the husband is turning the child against her and saying very awful things about her too, and that he's discriminating against her, he's defaming her, he's all of this stuff, setting her up, all kinds of things. But it's family court. But I have to give Judge Michael Dean credit because he answered it. She begged for a status hearing, and he did have a motion that he could do it. And to his credit, he actually this time considered her letter a motion, okay, of complaint of non-payment for contempt of court order. So they had a hearing on October 16th, and Judge Michael Dean had there the attorneys present for both sides. And lo and behold, here's another little sticky wicket for you. Do you want to know who showed up for Sarah Boone? None other than Frank Bankowitz. Yes, her previous attorney showed up just to tell that judge he would like to be excused from this case also and would no longer be representing her. But the judge decided that the complaint that she made, contempt, saying he was disregarding the agreement that was prior, which he is, if he's not paying, technically he is, except that he also filed a legal motion requesting that that agreement be looked at and altered, which stayed the process. He cannot make an order of contempt against the man that's in the process of having things changed. In other words, they have to have a hearing about whether or not to change the amount of alimony or whether it should be paid. And he put forth 2 warnings to Sarah Boone in there, kind of in a nonchalant way, but very true. The first one, he said that although Sarah could surely represent herself or anyone else, she would have to follow procedure and use the appropriate proper captions, titles, and certification of service for any further motions she would like to make to the court. And then he told her that she could press and file a motion to demand that the motion brought by her husband be heard and that the agreement be looked at and that a decision be made by Judge Michael Dean. But he also warned her in no uncertain terms that was her right, but he would have to take her current situation into consideration. So without saying it, he was kind of telling her it's not going to go in your favor. You don't need the room and board money. You're not taking care of the child. He'll get off of the alimony. He's saying, Michael Dean, that it might be in Sarah Boone's best interest to wait. And y'all know Sarah Boone hates to wait. It's going to be in her best interest because if she's proven not guilty in the outcome of her criminal case, then this man owes her all the money back, doesn't he? And he will be in contempt of non-payment. Now, we don't know whether, because it's family court, we don't get the records. It's okay, Juju. It's Liam. It's okay. Like, she's not cheating. She's just diversifying. She's just multitasking. It's a thing. You know. I don't want to be amused either, Juju B, by Frank Bankowitz showing up as the attorney, But damn, I was like, no kidding, really? Like he just had to make another point to another judge about how awful she was because he could have did that by letter. He didn't have to go. He did not have to go. Oh, absolutely, absolutely. But here's the thing. It's better for her to wait. Now, will she? I can't wait to see. I cannot wait to see. But basically, that was the news on her. She's got another case going on. There's another judge that she's like, and damn, she is a prolific letter writer. I did not know any of this behind the scenes. And apparently it's been going on for the whole full almost 4 years that she's been in there, you know? Hmm. Let me see if you have questions. It is indeed a quandary, as experts deserve to have their time recompensated, yet claims of impropriety are too easy to make. I do get it. I do get it. No one will lend her a few bucks. Those are some hard knocks. I'm telling you, no one's going to give her any money for this. And choo choo. Oh, Sarah, please shut your mouth. Well, at least God forbid there's a pen shortage. Sarah's going to go out of her mind. Like, paper and pen, if they deny her in the, oh my gosh, if they start limiting that, she's just going to be in problems. Mark says, I have an issue with paid expert witnesses. They have an incentive to testify in favor of the person that paid them. Yes, they do. And that's why I like the opposing side who brings up their prior testimony in other cases, makes sure that they're fully accredited, and actually holds their words against them. I love that tit for tat. I believe expert witnesses are necessary, but because they're paid, you can definitely find anybody if you do enough work to just about make your case for you. And they do go head to head against each other, and it's the ones that can actually prove they know what they know and why what the other person is saying is not exactly valid in a more credible way, that has a better history of testifying and doesn't come off as a paid expert as a career. In other words, those that have a career in what they are protesting to be an expert in or being used for their expert knowledge and opinion of, those stand better than the guy who, yeah, that's what he does, but basically the last 5 years, all he's done is testify in court. You know what I mean? Like the jaded view. It's a fine art, but it's definitely something we need because people don't testify. I mean, these paid experts they're not going to come forward on their own, like for the good, just cause. Okay, Mousy. Yes, she should still get her alimony. Okay. I I can understand why. I think I understand why you're saying that, but if you could expand on it for me there, because the alimony in this case was awarded, from what I understand, and I didn't get to see the document, so I'm just going to put that right out there. But Bryan Boone's motion seemed to include the fact that the alimony was based on her not having any visible means to support herself, and that she shouldn't be homeless or without food. And it was a bare minimal alimony to protect herself and also make sure she had a place so that when she had custody of the child would be in a safe environment. That's how that alimony kind of worked. She didn't get child support, but her alimony decision was based on that scenario. You're not guaranteed alimony because someone doesn't want to be with you. It is a whole wicked process. In my state, alimony goes to the person who earned the less money. If they can prove that they had a lifestyle that they're used to and you're leaving them and you made more money, or they might get alimony for a certain period of time, not forever, but a certain period of time, to acclimate themselves to a different lifestyle or to find other means to support that lifestyle. Because what they're saying is, you want to leave me, but that's fine, you can leave me, but you have no right to change my whole life, my whole world. In some courts will, actually, if it is the husband who makes less money, the wife will pay alimony. It's different than child support, totally different. This is spousal support. Alimony is, we're divorced, but you still have to pay me something till I get used to you be gone. Basically, it is not forever. And Sarah Boone's alimony agreement ends next year, actually the year after, in 2025. Um, you know, she had been living fine. She'd been living with another man. Obviously, her alimony does not have anything to do with whether or not she's with somebody else. Um, some of them do. Okay. Some of them don't. It depends on the agreement. Remember, this is family court, whole different set of rules. Okay. Um, but well, she isn't technically guilty, and that's true. And she may get out of jail. How is she paying her bills without it? Should she lose her home? She didn't have a home. She was a renter. So that doesn't come into play. But that's what the judge is trying to tell her. If she goes to court right now to push for him to pay that alimony now, or the judge to make a decision on his motion on regards to whether it should be paid, how much should be paid, or whether it gets negated altogether, she could lose badly. Okay. She doesn't own a home, and she doesn't have to pay for the child's room and board right now or feed the child. She's being taken care of. And that was one of the factors of her alimony. And I think that's why the judge put that warning in there. It's pretty risky for her to push for a decision on Bryan's actual filing. Bryan is filing saying, based on her conduct, like he has full child, he already has full custody of the child. Okay. He's going to have that just while she goes for this. I did not see any work history in any of her indictment, Juju. I did not even see it in her arrest record. I don't believe she did. But I would have to look a little further. And we'll have to look at that long interview with the police, okay? That she did, because it would come up in there too. But I have not seen it written anywhere. Usually I remember things that I see written much better than I do the visual videos and stuff like that. I don't know why. But when I go to the documents, I remember all of that, and I didn't see it in any of them. But I'm going to dig further. You always ask a good question and give me something for next week, right? I know, it was so long. It really was. Mousy says, that's part of the thing that bothers me about keeping people in jail until trial. Because even though she's a renter, should she lose everything she owns or the place she rents to keep those items? Exactly. That's right. She's without any funding whatsoever. Okay. We don't know if she was on disability or unemployment or some kind of social services. But when you get into the crime system, a lot of these things can stop. So I don't know if she has no money at all. I just know she wants that alimony. And right now, he doesn't have to give it to her direct. If anything, the court could order that he still pays it into a holding trust, that once his motion is heard, it will either take out what he's owed her or return it all to him. And they'll do what's necessary based on the hearing. But right now, he can't even file a motion of him being in contempt of court for not paying without coming into looking at his motion too. And that's what he's trying to warn Sarah about. You could see she's in jeopardy of losing it all. Liam said she should get paid as a professional complaint writer for people trying to return their broken toaster. I think she'd be pretty good at it. She's trying. But in this case, she got a response from the judge, but I don't think she's going to like what she got. But in this case, I think the judge is right. He is actually trying to protect her. I think he feels for her. He actually said in his response that there's not much he can do, but what he can do, he will. And he held that status conference because she said it's not fair that you're not. I have no real representation. Okay. But he said, even as pro se, you can do it in the right way. And from now on, you need to do it in the right way. And she can she can do it from jail. Now, he didn't mention her name. He just said blanket, like he's talking to the general public in there, like a footnote, so to speak. Let's place bets if she'll lose it all. Do you think she's going to force him to hold that hearing? I'm hoping she waits until her trial, because if she waits, she's got a better chance of getting it all. If she goes forward, there's a good chance. I don't think the judge would have put that in the order to warn her if he didn't already believe it was not going to go in her way, that there is precedent there. So she doesn't have custody of the child and she doesn't need room and board pay. Why should she get the alimony? There may even be a clause in there about immoral conduct. And if you're convicted of murder or on trial for murder, what if they're allowed to look at that? Yes, Juju, that's what I fear for her. She doesn't do what she should. Sarah Boone is her own worst enemy. She thinks she has total control of this. And she's just, you know, she has some valid points. And I think when you listen to the lawyers talk, you can hear them, right? They always say she has valid points. And we all agree. Her trial is taking too long. She's at mercy of the court system. We also went back and forth about her being overcharged for what happened. Um, and I have a little other caveat for you, Juju, based back on that a conversation that we had that I want to bring here and not to embarrass anybody, but just as a because you know what, guys, I don't do that. This is all about point counterpoint, and it's all about this side of the coin and the other side of the coin, and that's it. It doesn't matter who says it or what. It's about the context, the situation, or what we're talking about. Okay. So with Sarah Boone's charges, she's up for murder too. Okay. Which has an intent thing involved in it, like a grave indifference. Okay. She didn't give a shit. He died. Like it's her fault, period. Not manslaughter, which is he died because of something she did and she didn't interfere to change him. Okay. So I went back based on the fact that, I'm trying to figure out because during a conversation that we had in the Discord, like we do for crime discussions and stuff like that, Juju had brought up the point, validly so, with a couple of others, that why not manslaughter? That's like a slam dunk. Okay. Like that was a win. That was a total win for the prosecution. You could see with the evidence that they have, especially that video, that she was there, he was there, he was saying, let me out, and she didn't. Drunk or not, I get it. Manslaughter would have been a slam dunk for the prosecution. Why did they bring it up to murder too? I've always been perplexed about these. I couldn't settle on a good answer. And I think I may. I'm not the prosecution. I didn't get to talk to them. They haven't told me so. So this is kind of a little bit of speculation, but it's a theory I'd like to put there out for you. I don't think she had intent, but here's why the prosecution might. If you go back to that interview with the woman detective and the gentleman detective in the room, the really long one, where they're saying that Sarah Boone tried to take control of the situation, they showed her the video. And I caught something that I had forgot. And they made a big point of it. And they went over and over it with her about it. So I would suggest you all go back to that interview and look at what I'm going to bring up right now. And we can talk about it at a later time. Or even now, if you remember. Sarah Boone, in her affidavit about what happened, said that before she went to bed, she had flipped over that suitcase. Because remember, it was face down at one point. And then in another part of the video, the second video, it's face up. She said that she did move it. She admitted to it. And that she made sure there was an opening so that he could get out. And she said this over and over again while she's screaming at them that she has no intent. And they showed her the video. And if we look at the video, we can clearly see that there is no space, no unzipping of that zipper at all, not even a tooth. Like it is tight all the way. They caught her in a lie. She's swearing to God she opened it. And at the same time, she's saying, but I was drunk and I didn't know and I just fell asleep. I had no idea. But she's saying she opened it and they are actually showing her the video. It's no, you did not. Yes, you can tell in the video that there is no space because you could see the top where the tab meets the end of the suitcase. You know what I'm talking about? Like when you start to pull. She's saying she pulled it and left a gap and he could have clearly got out. That was in her mind. That's in her sworn affidavit. And I think this is what made them go to murder. Not only was she trying, acting like, she is like, I agree with you. She is a drunk idiot. She didn't know he would die. She did not intend on him dying. I get that, but now she's lying. And she went from manslaughter to murder. Like I see, Sarah Boone is her own worst enemy. Her own worst enemy. I still think she's overcharged too, but now I know why the prosecution was leaning this way. Why they started to believe this. It was their interactions with her in her own words, okay? And to me, that was just a way for me to try to figure out, like, just to satisfy my own question is, why are they going this hard? Really, seriously. Like, why are they spending the money to go this hard? It's kind of iffy, because I do agree with the majority that, it's even her grave indifference doesn't mean intent. She was drunk. She was altered. And that has to factor into it. And I do hope the defense puts that in there. Okay. There's a good chance she could get off. There's a good chance a couple of people on that jury are going to agree that she had no intent at all. It's just something that happened, that they're two idiots. Okay. And that the morons, and one got, like, killed. One died, but she didn't kill him. Her actions contributed to his death, no doubt. But if they don't put a step down charge in there, she's going to get off. And yes, Mrs. Cassandra, they caught her several times misspeaking or definitely lying. Yep. Yeah, but that's the problem with the defense. I also found a couple of the statements from the prior attorneys who did not. They didn't say what they brought to her, but that they brought viable defense options to her, and she would not cooperate, and therefore they could not agree on how to best defend her, and they opted out. They opted out. Because, like, they didn't want to come forth with and she wants this battered spouse syndrome. Basically, and I could see why. All of her statements in those videos, right, Mrs. Cassandra, they're horrible to watch. It's so heartbreaking to hear him. And I think it's heartbreaking for us because we know he's gone, But while she was sitting there, she didn't know he was gone. Wait, what again? What was what? Juju? Yes, there was, like, small statements from the other previous attorneys that they had a difference in defense tactics and things like that. Is that what you mean? They can't lie. I can see why the attorneys would bow out. They can't lie in court, or shouldn't. It's true. And they didn't think the jury would go with it. You see, they're entitled to their legal expertise, and they're trying to advise her that that's not the best way to go. It could have been plea deals too, but I've seen no mention of that. I was always curious why they didn't offer her a plea and to save money and be done with this, based on them finding that video. But it could have been that they did, and she wouldn't even look at it. Well, now I'm thinking the length of time at all. Is she going to look sympathetic to a jury? She could. I feel very sympathetic that she's been sitting in jail all this time, and that it doesn't look like the wheels of justice have been moving in her favor. And it does tell the story of the American court system right now, that if you don't have the money, you're last online. You're last in line. They'll get to you. You have rights, okay? You have rights, but they'll get to you when they do. You're not going to be first served, you know. And that's the thing. In the other part that we were talking about, in the family case, in the divorce case with the alimony, there is no protection to guarantee you an attorney. She has to represent herself or hire an attorney, or ask the other attorney, like Bankowitz, who came over. Maybe they had a conversation and she said, can you just attend this hearing for me? Or could you just file this? It's not a lot, I'm not getting my alimony. But basically the motion, as a contempt motion, came from her letter, not from Frank Bankowitz. He showed up, but mostly to get excused because he was attorney of record, and he wanted himself removed as attorney of record for her in this case. It didn't go well for her. I don't know why he didn't do that, like, with the form beforehand. Sarah Boone letter was submitted, and they would have had the status hearing anyway. Well, it probably went quicker because somebody was there. And basically, the order would be issued to Sarah, and she would read it, and hopefully she takes the underlining tone of it and does what's best for her, and shows it to with Winston Hobson, who is her new attorney, and hopefully he will just at least advise her on it. They should definitely put a layered charge rather than putting all their eggs in one basket. I do agree. I do agree. I do think a step down, if if you're not 100% on guilty, then, whatever, they should have done that. But, those are iffy too. Her attorney should use that family court matter as leverage to get her to zip it and go with a valid defense. You know, Juju, you think like I do. I hope he does too. I hope she brings it to his attention. She shows this to him. She confirms what I and several of the videos I saw, some of the lawyers and some of the not lawyers, everybody's agreeing. That was a message from Judge Michael Dean. Sarah, I hear you, but this isn't in your best interest. Think twice before you force me to actually put out an order based on your husband's motion, because I have to do that first to do yours. There is no contempt while there's a motion on the floor in regards to the alimony. Bryan's not obligated right now to do anything until the court decides. But if you force the court to decide, it may not go in your favor based on your current situation. And I know that's going to be hard for Sarah to hear. But it is better than the silence that she's been getting. So in a way, it's a win for her. Someone acknowledged it and did something. And at the same time, they set her straight. They said no more letters unless you file them with the proper titles, captions, and certificate of service. Like, do it the right way. You don't, have to use all the legal mumbo jumbo. You can represent yourself. There's a good way. I'll accept it. Just do it right. Yeah. Well, she can send letters. They just have to be in the right format, Juju. He said she's perfectly capable of doing that from jail. So and he's demanding it because, I think he understands that she may be representing herself, and if she has and I think he thinks she has a valid point, but he's trying to tell her how the system is going to go against her. She has a valid point, and I think he feels for her. I think anyone in the legal system would be giving her a nod at least on how long she's been there with no results. These are not the wheels of justice going in a timely manner at all. With no ability to pay for expert witnesses, she can also use that for possible mistrial or at the very least contest. Exactly. And that is what Judge Wooten was trying to prevent. They were having hearings before Frank Bankowitz decided to leave. He had them there to testify as to why they wouldn't give more money and to try to get them to give more money. But he can't do that order now until they have another hearing. And now Winston Hobson has actually asked for more time. So they're not going to have that hearing till January. But hopefully that expert witness is still going to testify and their defense will go forward. Now, he has confirmed that he and Sarah have spoken, and that's the defense they're still going forward with. The prosecution is still pushing forward. I would like to talk to them about that, but I don't get it. Me either. I would like further explanation. But if you go look at that and you hear how they're questioning her, you'll see where they're going with it in regards to her statement of what happened and the actual visual evidence that they have not actually lining up with it. And then they're going, oh, why are you trying to cover up? They already were sketchy with her trying to intercede herself the whole time they were there. Everyone who did an affidavit on it said she was acting that way, always trying to get information from them. And I get it. She was nervous. I mean, but I would be nervous too. But her behavior didn't go to her credit either. And it kind of set her up for the situation that she's in. But I think on that, I think that's it. I think that's all I have, that's all I have on these. Hopefully it gives you guys something to talk about. I do have some things on political trials that are going on right now that are quite interesting, and I will be coming forward tomorrow someday with that. The discussion on the Republican candidates that I was having with Chris from Hereticals has been scheduled for Thursday night now instead of Wednesday. Chris had to move it. I don't have the exact time yet, but it's probably earlier rather than later. But I will post it on my community tab as soon as he posts up the video. And then we'll have the normal weekend kind of things going on. For those of you that are members, we are looking for book club this weekend. If you guys have preferences for time on either Friday or Saturday, please let me know. In the meantime, I'm not sure if Mousy is going live on Wednesday, but I know Mrs. Cassandra and Shenanigans has something planned for Thursday, so I hope that you'll check them all out. I hope that you will like, subscribe, and check out, all the things for my channel. Help me out with a couple of comments. It does help us stay in the algorithm. The more we're in the algorithm, the more people see what I'm covering. And believe it or not, the more information I get. So not only are you helping me and the channel, but you're helping you too with the quality of information and things we get to discuss. So a little more effort, it can go a long way. And I would greatly, greatly appreciate it. So. And on that, I think we're going to hand it up. Okay. Don't forget to like the video. Yup, that's it, Liam. You tell them. And thank you, Anna. Thank you too. Oh, and hi, Commander. I didn't see you come in, but I'm glad you were here. I hope you had a good day. All right. So I didn't see any questions that I left unanswered. But if I did, don't hesitate to call me out on the back of the chat and ask it. I will answer you. I will. Okay. All right. Y'all have a great night.